The loose microphone. Miles, you have a PowerPoint too? Okay. And however you want to do it again, you can walk out onto the floor, stay here or up here, whatever you want to do. Whatever works. Yes, sir.
This remote works and I can, okay. So he'll put up the first one and check it. That way. Yeah.
I'm not going to be up here yanking you off the stage or anything.
Good to know.
Let me introduce you first, please. Okay, I'm going to get this started because this is, again, important. People have a lot of things to say. So hang on one second, and I'll do that. So, the last panel of our meeting, we'll start with Noreen Walsh. She's the Regional Director, the Mountain-Prairie Region of U.S. Fish and Wildlife Service. Followed by Miles Culhane. Some of you were in Boise, might remember Miles. He was a panelist at our meeting there. He is the Managing Counsel for Occidental Oil and Gas Corporation. Then Jay Tutchton, Senior Staff Attorney, Defenders of Wildlife. Robert Fischman, who's a professor at the Indiana University Maurer School of Law. And finally, Norman James, attorney, Fennemore Craig. The topic, legal analysis of the Endangered Species Act. Sort of the mother panel in some ways. That's why we're all here, is that act. All right, Noreen.
Good morning, everybody. Can you hear me? Here we go. So they told us we had very limited time for our remarks, so I know I'm on a clock and I don't have time for jokes, but I just have to tell you that when I was listening to Chris West claim that they might have the worst acronym, I was hearkening back to just a few years ago when my younger daughter was seeing USFWS written on a whole lot of things, and she came up to me and she said, "Mom, what does UFSWS stand for?" UFSWS. I think if we decided to adopt that, Chris, we would beat you. So again, my name is Noreen Walsh. I'm Regional Director for Fish and Wildlife Service for the region that's headquartered here in Denver. And I want to spend just a little bit of time talking about some of the improvements that we have been working to make to the ESA through policy and regulation changes. So you'll see here the overarching goals that the service has had for the things that we've been working on changing through policy and regulation for the ESA. In particular, we want to improve our conservation effectiveness. We're trying to reduce administrative burdens and reduce litigation. And most importantly, we're trying to improve and enhance and encourage partnerships and collaboration in the administration of the ESA. You saw these same overarching goals, those of you who had a chance to hear from Gary Frazier yesterday on the stakeholder panel. So I won't have time this morning to go into a lot of detail, but I will talk about some improvements we've made, and they are loosely organized into these 5 categories according to the sections of the Act. So on the listing front, we have been, in May of 2015, we put out some proposed revisions to our regulations that govern the petition process, the process by which people can petition the service to add species to the list. We wanted to provide greater clarity to the public. Honestly, we wanted to improve the quality of some of the petitions that we receive, and we wanted to maximize the service's efficiency because, as we've talked about this morning, a dollar only goes so far, and we don't have time to spend on things that don't really matter. The proposed revisions, among other things, would require only 1 species per petition. That would mean the service would not be receiving the kind of mega petitions that we have over the last couple of years where hundreds of species are petitioned at the same time. And in addition, the proposed revisions would require that the petitioner make advance notification to the relevant state fish and wildlife agencies, share their petition in advance to the state agency, and give the state an opportunity to provide information and comment on the petition, and have that information appended to the petition when it comes to the Fish and Wildlife Service. We have received a great many comments on that proposed reg revision, and we will be putting out a revised proposal within the next several weeks. So be on the lookout for that. Also, many of you are aware that we put out a proposed policy for how we will prioritize the petition review, the status reviews and petition findings that are in front of us. We have a backlog, a queue of over 500 species that require status reviews and 12-month findings. We have published this proposed process of how we would prioritize work on those petitions and any subsequent listing determination that comes from them. And roughly speaking, as one of the earlier panelists mentioned, we would categorize them into 5 different categories. Those that represent species that we know very well are critically imperiled. Next, species for which strong data is already available. Next bin of priorities would be species where we have a petition but new science is actively in development that should inform the ultimate answer. Next, conservation opportunities are underway that may impact the threats that have been recognized to the species. And then last in line is the bin of species for which limited data is available. So we're trying to be very objective, have a strategic process for working through these species that are already in front of us, and be very transparent with all of our stakeholders about what that process and what that lineup looks like. And we will be putting out later this year a work plan for what that schedule, a national work plan for what that schedule looks like for all of those species. So moving on to everyone's favorite topic, critical habitat designation. Critical habitat, as many of you know, has been one of the most challenging and controversial parts of our job in administering the ESA. We have litigated, others have litigated over our decisions for many, many years. We do accept, and the proposed or final regulations that we will talk about accept that it's our statutory duty to designate critical habitat. The Act calls for us to do that with very limited exceptions. But we have incorporated 20 years of experience in how we designate critical habitat so that we can do it in the most intelligent way possible, so that we can make sense of this process, so that we can reduce the conflict and the litigation and get the kind of conservation that we can out of this requirement. One of the first changes we made to our critical habitat regulations was to say that we will publish the draft economic analysis at the same time we publish the proposed critical habitat designation rule, so that the public has an opportunity to comment on both of those at the same time. We also simplified the analytical process. In particular, removed what was a confusing concept for many called of primary constituent elements. But more importantly, really, I think, is the work that we have done in regulation to better articulate how we decide what might be excluded from critical habitat. So most of you know that we always propose all of the areas that meet the definition of critical habitat, those things that are those areas that are essential for the recovery of the species. But before we make a final determination on what will actually be in the final critical habitat designation, we balance the benefits of designating any particular area with the costs of designating any particular area, whether that's economic costs or impacts to national security or other impacts, to do that weighing act before we finalize the regulation. So the new policy on exclusions from critical habitat makes it very clear that we are trying to encourage voluntary participation in conservation efforts and conservation plans. Thus, the policy establishes that we will, as a general rule, exclude areas that are covered by an HCP, a habitat conservation plan. We will exclude areas that are covered by a safe harbor agreement, and we will exclude areas covered by CCAAs. What about federal land? As a result of this policy, as a general rule, federal land will not be excluded from the designation. The reason for that outcome is that, as many of you know, that really the only substantial impact of critical habitat is to add another element to the analysis that we do during Section 7 consultation. Actions that are happening on federal land that may impact listed species are coming into the consultation process anyway, and federal agencies have an affirmative duty to work towards the conservation of these listed species. So because of those reasons, as a general rule, we will not be excluding federal lands from critical habitat designations. Continuing with Section 7 consultation, the definition of destruction or adverse modification. A Section 7 consultation about effects to critical habitat focuses on this phrase, destruction or adverse modification, whether the action is likely to destroy or adversely modify critical habitat. And our previous definition, regulatory definition of destruction and adverse modification, was struck down by the courts. Our new definition is a direct or indirect alteration that appreciably diminishes the value of critical habitat for the conservation of a listed species. Appreciably diminishes the value of the critical habitat for conservation of the listed species. Those alterations, they may include, but are not limited to, things that alter the physical or biological features necessary, essential to the conservation of a species, or that preclude or significantly delay development of those features. Folks ask us, do we anticipate this new definition will result in more adverse mod calls or fewer adverse mod calls? And really the answer is neither. This definition really codifies the way we've been doing business for about the last decade since the original definition was struck down. So I don't think it will make a material difference in more or less adverse mod designations, but I think it will help our biological opinions to be more defensible if and when they are challenged. We are also working in the Section 7 consultation arena on a streamlined process for projects that are designed to provide net benefit to listed species. We only have so much consultation, energy, and resources to devote to these analyses, and there's no sense spending a lot of time on a project that is designed by its very nature to have long-term benefits to listed species, but which may have short-term impacts or may have some take in the short term. So we're working on a very streamlined process that ensures we encourage those kind of projects and we don't spend more time on them than is necessary. In the arena of voluntary conservation plans, voluntary pre-listing conservation actions. We put out a proposed policy on this issue on pre-listing conservation actions That was developed in collaboration with the state fish and wildlife agencies through the ESA Joint Task Force. And it was released for public notice and comment in July of 2014. The policy is designed to provide another incentive for people to work very early on conservation actions for species and to get some credit for it. So this policy would establish that conservation actions undertaken before a species is listed, if they're in accordance with a state-sanctioned conservation plan, could be given credit in terms of compensatory mitigation if the species is listed in the future. We expect it will create a market for conservation banking for candidate or imperiled species, creating economic value for those conservation efforts. It's important to realize that this proposed policy envisions that the states or their agents have the lead for, are in the driver's seat for developing and administering the conservation plans for those species. Habitat Conservation Planning Handbook. We're working on a revision to this handbook right now that will incorporate the lessons learned over the last 20 years in reviewing HCPs and issuing incidental take permits. Our explicit purpose in doing this is to make the process more efficient and more effective so that more people will be willing to use what is a highly effective voluntary conservation tool. Collaboration with the states. We have recently put out an update to our 1994 policy on how we work with state fish and wildlife agencies in every aspect of the administration of the ESA. And again, our purpose here is to have as close of a relationship as we can and incorporate the advice and the expertise of the state wildlife agencies as we move through listing, consultation, recovery. That policy was put out recently and is out for public comment. So in conclusion, I would say we have 40 years of working under the ESA, and it is our objective to continue improving the implementation of the ESA as we move forward. That's why we've embarked upon these administrative or policy or regulatory changes. But it's important to recognize that over this time that we've had the ESA in place, the ESA has prevented the extinction of hundreds of species, and that is a success, and it's our interest to work with all of you to build on that success, to have a more efficient and collaborative process. Thank you very much.
Can you hear me? I need 3 hands for this presentation. And this is not my presentation. Oh, there we go. That's why, this is why I'm in control. Somehow, I came to the same conclusions as Robert came to from different points of view on the importance of cooperative federalism to the ESA. Now, I don't know if it counts that I came to that conclusion 10 years later, but I was surprised to find some papers of yours after our conversation about it, talking about cooperative federalism. So nobody was listening 10 years ago is all I can say. Hopefully they'll listen now. That's why you're here now, that's right. And I've got 5 to 7 minutes to legally analyze the Endangered Species Act in its entirety. I was told maybe I should sing it. If I only had a brain. To delve into this, and it's going to be a real big picture item though, a real big picture look, to delve into it, I'm going to go back in time because the 70s was a period, the early 70s was a period of an explosion of environmental legislation. One of the facilitators talked about a Pandora's box earlier, reference to Pandora's box. Well, really, this was an opening of a Pandora's box. In 1969, we had the Santa Barbara oil spill. We had a lot of coverage for the Cuyahoga River in Cleveland burning. The first Earth Day was in 1970. So there was an awful lot of interest in environmental areas at this time. And it led to a lot of acts that embraced this concept of cooperative federalism, where there's a very strong formal role for the states. And we're going to take a quick look at some of these to help inform what I think is the answer, some of the answers on the Endangered Species Act. So the first one is Clean Air Act. Can you all see that? I blow it up. So the Clean Air Act includes provisions for state implementation plans. Now, for those of us who keep being told that we cannot change this act, it's so difficult to open up this act, I want to call your attention. In 1970, when this was written, the states, and I'm sorry, somehow in translation to your computer, my little arrow got misplaced. The states used to have 9 months to put in an implementation plan to EPA for approval. That was what it said initially in 1970. You had 9 months. This was totally unworkable. And it took 20 years, but finally in 1990, the act was amended to provide for a 3-year period for submittal of your plans. Now, who was president? This is the interactive portion. Who was president in 1990? George 41, right? George H.W. So, and who was the Senate Majority Leader? Amos? Who was the Senate Majority Leader in 1990? The Senate Majority Leader in 1990. George Mitchell from Maine, right? Senate Minority Leader, he was a Democrat. President was a Republican. Senate Minority Leader, anybody? Guy from Kansas, Bob Dole. And probably Speaker of the House. I bet you nobody remembers the Speaker of the House. Tom Foley. But these acts can be changed. I mean, this is the Clean Air Act. This is the air we breathe. This is a controversial act. And I'm not endorsing the language in this. This is very strong language. Each state shall do this. A lot of us would probably have a little bit of a problem with that sort of language nowadays, but that's the language of the act. Each state will submit this, adopt a plan, and submit a plan. And we've got the Clean Water Act. The administrator shall prescribe conditions for permits to assure compliance. The permit programs shall be subject to the same terms and requirements as apply to state permit programs. So strong language for the states to have a strong formal role under the legislation. Other provisions, the governor of each state desiring, it's not, as opposed to Clean Air Act, we're not ordering the state now. But if the governor desires to administer its own permit program, they may submit a full description of that program, and then it gets approved because the administrator shall, the EPA administrator shall approve it. This is strong language that controls these things. We've got the Endangered Species Act. Now we get into Section 6 of the Endangered Species Act. In carrying out the program, the Secretary shall cooperate to the maximum extent possible. This is a little softer language. The shall cooperate. I mean, the shall is still there, but what does cooperate mean? And then the Secretary may enter into agreements with the states for the administration and management of any area established for conservation of species. And this is all found in Section 6, and there's provisions in Section 4 that reference the states. But these are important provisions of the Act that perhaps in the Endangered Species Act are not as strongly worded as the Clean Water Act and the Clean Air Act. But I think there's room for interpretation here that Fish and Wildlife could engage in order to strengthen the role of the states if they're willing to take on this role in managing endangered species. And cooperative agreements, language in Section 6, C1, the Secretary is authorized to enter into a cooperative agreement with any state which establishes and maintains an adequate and active program. And I think this is a requirement for Fish and Wildlife to enter into these sort of cooperative agreements. And so these are important provisions. I think there's room here for a stronger state role under the current provisions of the Act. But I would argue that, as Governor Mead said yesterday, there are opportunities here to strengthen that. Not the least of which, of course, is that there's a 1-year, the 12-month provision from proposal to listing to listing. I mean, those timeframes can be changed if they're simply unworkable, and I would argue that they are currently unworkable. So I would suggest a two-pronged approach. The first is to actually have the courage, have the boldness to try and amend the Act through Congress to strengthen Section 6. Perhaps also have to decide just how to approach Section 4, which is the listing provision. If we've got a stronger role for the state, who is managing that listing process now? Is it still at the federal level, or is it at the state level? And that's something I think we should be discussing. But I'm not suggesting a wholesale change of the act. I'm suggesting surgical strikes to try and improve the act. But I also suggest that the second prong of this approach that should be taken concurrently is to continue to work. The policies that Noreen is talking about, the regulatory revisions that have been suggested, they're very important. And I think we need to continue to push as a group of individuals that are interested in getting greater efficiency out of the Endangered Species Act. I think we need to continue to push for a broad interpretation of Section 6 and what it allows for state and local roles. Now, I want to be very careful here because I'm not talking about a weaker Fish and Wildlife Service. I'm not talking about somehow diminishing their role or their capacity. I'm talking about stronger state and local roles. Just as we see with the Clean Air Act, just as we see with the Clean Water Act, there are very important roles for the state to play, and there continues to be a very important role for EPA to play in oversight. But the states should be given that opportunity, and I'm not suggesting that they haven't, but you'd be given a more formal role in delegated the responsibility for administering the Endangered Species Act within their states. This can be done. I mean, water, the headwaters of the Missouri start in Montana, they flow all the way down to the Missouri, they combine with the Mississippi, they go through multiple states. We have species that cross multiple state lines. We have water that crosses multiple state lines. We've got air that crosses multiple state lines. States can regulate it, and they should be able to do so. I think these are some of my thoughts. They're a little incomplete, but I think that this produces a more equitable balance of federal, state, and local interests, because we need to be able to have those state and local interests be heard on a consistent basis and not marginalized. The focus has shifted, I think, from listing to recovery. I don't know what Noreen would say, but I see an agency whose resources are taxed to their limits by trying to keep up with listings, when what we really want to be seeing is recovery of species. I don't dispute that several species have benefited, but if I was talking to some folks last night, I've seen a graph that shows in real dollars the Fish and Wildlife's budget in 1973 for managing 19 species. I forget what the number is for the first group of species. In real numbers, the money that was being devoted to managing 25 species is the same amount they have now to manage 2,000 species. And you can do the math. You have 1/100th per species of the amount of money to spend. I think if we get the states involved, we'll see increased funding. Now, this is a little bit of a magic bucket at the end of the rainbow, because we keep searching for more funding, and there's not a whole lot of funding out there. But I think the states who understand how to administer clean air programs, understand how to administer clean water programs, understand how to administer their permit programs, can find the money and help find the money. I think you'll see enhanced local interest. We push it down to the states. We have a formal process whereby the states are administering the program. I think you have easier access to those state officials. There's increased accountability. I think if you have your state officials administering the act, they know that the local people are being affected. They know those decisions are going to affect their local districts. I think it'll result in greater faith in the process. I don't know that there's a whole lot of faith sometimes in the process, from what I've heard the last couple of days. I think if we involve the states to a greater degree, we get greater faith in the process. And I hope it leads to decreased litigation. Now again, I'm not suggesting that we have a weak Fish and Wildlife Service. I'm suggesting a stronger partnership role for the states and local governments, because we want the focus on recovery. We want efficiency out of the money that we spend for the act. We want greater local control, which I've heard from a number of people here. It's said in many different ways. We want that local control. Policy amendments and revisions from Washington, even when and I appreciate that most recently they've involved a cooperative framework, but oftentimes it's seen as Washington driven. And we do want species recovery. Thank you very much.
Hi, I'm Jay Tutchton from Defenders of Wildlife. The lawyer in me needs this podium, and I don't think I'm as tall as you, so I'm gonna stay up here. I'm gonna talk about the listing process, and I should probably start with a confession because we've heard quite a bit about it. The MDL settlement, I'm one of the people who negotiated that, and so I feel a little bit defensive, and I need to say a few things about it. It has gotten labeled with this pejorative sue and settle tag, which implies it was collusive. And I just want to tell you, it was not in the least bit collusive. It took the government 6 months to consolidate the litigation in Washington, D.C., a process my client resisted at every opportunity. We didn't want to go to D.C., and we didn't necessarily want to get into a big settlement. We were happy proceeding one case at a time the way we had been doing for 15 years. After we got to DC, the negotiations took 8 months. We were court ordered with a mediator. They were contentious. I think everybody there probably thought about throwing the towel in at least once and letting the court sort it out. I know I had to walk my client back to the table multiple times. Gary's a very nice man, but he's got a great poker face, and he's tough to negotiate with. His compatriot, Michael Bean, was the guy whose textbook I read. And so I think my client felt a little outgunned the whole time because they had the student, and Fish and Wildlife Service had the master. But at the end of the day, we did reach a settlement. The point of that being, we stopped additional litigation. So to the extent you want litigation to stop, you should encourage settlement, not criticize it. The alternative to settling that case was approximately 24 cases continuing in different forms and possibly reaching inconsistent results. But the other important point is that settlement took the environmental group's foot off the gas in terms of filing petitions and allowed the Fish and Wildlife Service to work through a list of 251 species, which they had already concluded warranted the protection of the act, but they were too busy to get around to actually protecting. So, and by and large, with a few exceptions, we let the service pick the timeline for when they were going to do those. 5-year total timeline, but the service was setting the exact dates within there at their own discretion. Instead of a judge, that's the other alternative, is a judge does that for you. At the end of the day, I think it was a good result that let the service prioritize and finish the work on these 251 species, which had already been identified as those most likely to need the Act's protection. And on average, at the time we entered into negotiations, had been waiting over 10 years on the warranted but precluded list. So it wasn't like there was a great rush to judgment here. Those things had been sitting around for 10 years in the highest possible flag category, warranted but precluded. And we gave a 5-year work plan to get through that. I got to say there was no smoke-filled room also. The negotiations took place in a federal building, which banned smoking at times, much to my chagrin. But there was certainly no smoke-filled room. And one last thing on it, because this EJA issue has come up a couple times. I think I probably spent 10 nights in Washington, D.C., at least during these negotiations, most of which, because my client couldn't afford a hotel room, were spent in a very comfortable chair at National Airport, an air mattress in the very crummy apartment of one of Bernie Sanders' staffers, or my girlfriend's parents' house in Frederick, Maryland, which gave me a 2-hour train ride to get to the meeting. Those aren't necessarily fun things, and I challenge you to get a corporate lawyer to do that for you. If you can, you're very persuasive. But back to this, the listing process. As we all know, the ESA works on the principle of the magic list. If you're on the list, you get the protections of the Act. If you're not on the list, you don't get anything. The people I've worked for over the years spend a great deal of time trying to put things on that magic list. And you might reasonably ask why or find that a bit objectionable. I want to explain why we do it. We view that list a lot like Oskar Schindler's list. If you're on the list, you've got a decent chance of survival. If you're not on the list, things look a lot worse, potentially. Yesterday, Governor Mead pointed out that the Endangered Species Act has something like a 1.4% success rate in terms of delisting or recovering species. That's statistically true, but I don't believe it's at all accurate as a measure of the Act's success. The true success of the Endangered Species Act is that 99% of the listed species are still here, in that we've kept them from growing extinct. There was a scientific paper published back a few years ago now that said, but for the ESA, we would have lost an additional 400 species in the United States since 1973. At least in my mind, that would have been a terrible outcome. And the fact that the Endangered Species Act prevented that outcome, I think means it was actually been a profound success. You know, Governor Mead and I are looking at the same data set. We're just looking at it in different ways. But I think you need to look at it as a two-step dance in terms of the goals of the Endangered Species Act. The first step is prevent extinction. Right? We're doing a very good job of that, 99% success rate. The second step is recover the species. We've got some work to do there, and there's a lot of reasons for that, which are beyond the scope of my talk. But the Act is a success. I would not at all characterize it as a failure. The second reason we try to get species on the list is maybe a bit more controversial. And here I agree with Governor Mead that the necessity to list a species is a failure. The question I ask, though, is whose failure? All right? By the time you're talking about listing a species, the states are the primary managers of wildlife prior to listing. Fish and Wildlife Service does not manage unlisted wildlife with the exception of a few things like ducks. But at least out here in the West, it's the states and the federal land management agencies that control much of the landscape. By the time the species reaches the need for listing, those entities have failed. All right, so what we try to do with listing is to transfer responsibility from entities that have failed to a new manager in the hope that getting a new captain will right the ship. So I agree that listing is failure, but you got to look at who failed to get you to that situation. You know, the last reason we try to get species on the list, and this might also be a bit controversial, but the list is too small. It's just a scientific fact. It's under-inclusive, it's under-representative. Neutral scientific services like NatureServe, the State Natural Heritage Programs, the IUCN, International Union for the Conservation of Nature, would tell you there's probably 6,000 to 8,000 critically imperiled species in North America. ESA list has about 1,500 of them on there. So for better or worse, the ESA listing process is one way to get people to do things. And you know, this is a broad point, but we are in an extinction crisis. The rates of extinction are unprecedented. You know, again, scientists call it the sixth extinction, comparing it to the meteor that wiped out the dinosaurs. And we are in a hurry because we see this crisis and we want to use what has been the best law we've got to prevent extinction. So that's a little bit about why we do it. I want to give you a look inside the hood too on the listing process from our perspective in terms of the focus on deadlines. And I'll use the lesser prairie chicken as an example. So in 1995, a woman named Marie Ellen Morrissey filed a petition to list the lesser prairie chicken. She's a homemaker, all right? She's got some time on her hands. She loves wildlife. She researches the lesser prairie chicken. She files a listing petition. I was running a small law clinic at the old DU campus at the time. She calls me up and says, hey, I filed this petition. I think the species needs protection. I've read this statute and it has these 90-day and 12-month deadlines. And I want you to enforce these deadlines for me because no one responded to my petition. I thought she's exactly the kind of person that a citizen petition process is designed for. A regular citizen who's concerned about something and wants the government to respond to her concerns. But I grew up hunting lesser prairie chickens, which I actually found pathetically easy when I was younger. I didn't really know if she was right. So I took a trip down to southeastern Colorado to areas I used to go, hunted on the national grasslands for 2 or 3 days. And finally on the third day when I found some lesser prairie chickens, which had taken that long, I actually couldn't shoot them because I literally felt like I could have been shooting the last batch of lesser prairie chickens on the Comanche National Grassland, and they were also right by the lek where they take the school kids out, and I just couldn't do it. And so I came back to my office and said, I think she's right. And so we talked, and she said, well, file the lawsuit for me. I said, I can't do it now. This is 95, 96. Congress zeroed out the listing budget and put a moratorium on all species. I said, well, let's talk after Congress gives the Fish and Wildlife Service some money. 1996, the moratorium came off, and we ended up filing the lawsuit. 90-day finding came out in 1997. 12-month warranted but precluded finding came out in 1998. When I won that case, I got $8,000, just for you who think that we're all getting rich off of our EJA fees. That warranted but precluded finding said in 1900, there were 2 million lesser prairie chickens just in Texas. It has a 5-state range. But 1900, 2 million just in Texas, doesn't count Kansas, Oklahoma, New Mexico, or Colorado. 1970, there were 60,000 in that 5-state range. 1980, there were 44,000 in that 5-state range. 1998, they said there were close to that many around. They had a kind of wide-ranging survey estimate, but the population was declining. Bree was partially happy with that warranted but precluded finding. She was glad the service had agreed with her that it was warranted. She was upset by the but precluded part. So she called me back and said, can we sue over that? I want them to finish their work and actually protect the bird. I said, that's a little different nut to crack. We will have to prove that they're not working on something else, that they're not working on higher priorities, and we got to see what they do. We got to give them some time. She would call me back at least once a year and say, how about now? We journeyed through the second Bush administration where literally maybe 8 species were listed. Almost nothing happened. And I finally became comfortable as a litigator saying, all right, we'll file the warranted but precluded suit because they aren't working on anything. And I'm comfortable that we can prove that they're not working on higher priority items. Filed that suit in about 2009, 2010. And then in 2011, we got involved in the MDL settlement discussions, and we settled this lesser prairie chicken case as part of that settlement in exchange for a deadline. And again, I think for that portion of the case, 10 nights on an air mattress in DC, I again got about $8,000, just to put a dollar figure on what EJA fees look like. After the MDL settlement, forced action, 2012, the Fish and Wildlife Service proposed the bird is threatened. 2013, I finally noticed someone doing something for the bird. You started to see CCAs, CCAAs, draft 4D rules. People got interested seriously in conserving that bird. Not in 1998 when the service said it warranted listing, but in 2013 when the service proposed it for listing, and listing seemed imminent. And that's my point, that deadlines matter. The service then took a 6-month extension, gave people another 6 months on that proposed listing. And then finally in 2014, they listed the bird, and there were about 34,000 was the best estimate they could come up with in 2014. By 2014, Marie Ellen Morrissey was dead. Just to sort of put a face on what happens to a citizen who participates in this process. My point in telling that story was to say, delay matters for a couple reasons. If we'd have worked on this bird earlier, it would have been easier. We had 60,000 birds to work with instead of 34,000 birds to work with. In terms of whether we forced the deadline too quickly, there's no higher trigger than warranted but precluded. There's nothing else the Fish and Wildlife Service could say that we're thinking very seriously about listing this bird. They said it in 1998, but nothing happened until we set a deadline. And that's because, like for all of us, deadlines matter. We're a deadline-driven society. They may be uncomfortable, but I think they're necessary to drive processes forward. And whether you agree or disagree with the result, at least somebody made a decision, people took action, things happened once a deadline became apparent. Okay, I want to spend just a couple minutes talking about what I see as emerging issues in the listing process. First off, I think you have to pay attention to what I call a listable entity. The Endangered Species Act actually says you can list 3 different kinds of things: a full species, a subspecies, or a distinct population segment of a vertebrate species. I mention this because you have to pay attention to what gets listed, which of these 3 categories the listing takes place in. And just to give you a quick example of how this matters, if you list wolves or grizzly bears at the species level throughout their range in the lower 48 states, you're going to have some legal difficulty when you try to chop that species level range-wide listing up into DPSs for delisting purposes. And that's why the Great Lakes wolf DPS proposed delisting was rejected by the courts. Because the court looked at it and said, you listed wolf in gray wolf in probably 38, 40 states, and you proposed delisting it in 3. And we don't understand why you didn't, if you were going to recover a DPS, you should have listed a DPS instead of list the whole species and then recover it in three states. The second thing I want to mention is the Act provides 2 classifications which have, I think, been lost over the years: threatened and endangered. They're supposed to be 2 different things, and it was supposed to be a hierarchical system, with an endangered species being threatened with extinction right now, and a threatened species being one that's likely to become endangered within the foreseeable future. The Act provides those 2 different levels of species with 2 different categories of species with different levels of protection. By some provisions apply to both threatened and endangered species: critical habitat, recovery planning, Section 7 consultation. But the direct statutory text of the ESA only applies to take prohibitions to endangered species, and they're reduced for plants as opposed to animals. There's a provision in the Endangered Species Act known as Section 4D, though, that lets the Fish and Wildlife Service or the National Marine Fisheries Service, as the case may be, elect to provide the take protections to threatened species. The 2 agencies address this authority in directly opposite ways. Fish and Wildlife Service proposed or promulgated a general regulation that provided take protection to all threatened species. NMFS did exactly the opposite. They said take protections don't apply to any threatened species unless we issue something that's become known as a special 4D rule. So when NMFS issues a 4D rule, they are adding protection to species. Fish and Wildlife Service issues a special 4D rule, they are removing some of the protections from species. And why I wanted to explain that is we've seen a noted uptick in the use of the 4D rule by Fish and Wildlife Service over the last several years. I view this trend as potentially problematic from my side of the fence because it results in a listing with substantially reduced and potentially ineffective protections. Tempted to use the Gunnison sage grouse as an example, or the lesser prairie chicken, but I'll pick something further away so I don't ruffle too many feathers. The northern long-eared bat is a species whose population has declined 98 to 100% largely because of a disease. Fish and Wildlife Service proposed it as endangered. They ran into a maelstrom of opposition. A year later, they changed their minds and listed it as threatened. Nothing had changed, and then which you wonder why it went to threatened. And I think part of that logic was so that they could propagate a 4D rule, which reduced take protections. I could explain what I find fault with that 4D rule, but Zach gave me the wrap it up sign, so I'll sit down and let Norm talk.
I'll let Rob talk first.
Oh, Rob, sorry.
I'll talk first. And I want to first thank the Western Governors Association for inviting me to participate. I'm an academic and I publish in obscure academic journals, and it's a great opportunity for me to talk a little bit about my findings and to bounce ideas off of you all who are intimately involved on the ground and in the water with species conservation. Let's start with some propositions that I think will be widely accepted before we get to these cooperative federalism issues, which may be more contentious. Most declining species in the United States are not on the brink of extinction. And states, particularly through the state wildlife action plans, have tremendous potential over the long term to play the dominant role in conserving species and in reducing population declines. Part of why I think we find ourselves in the situation we do today is because of the problems of very low funding for recovering endangered species, and we're torn between the deadline-driven and biologically driven imperatives of preventing extinction while doing very little comparatively to prevent the trickling down of those declining species into imperiled status. So I think probably the most important long-term step would be to empower states, and that's going to require money. It's going to require closer partnerships with private landowners and businesses to empower the states to implement wildlife action plans and to engage in conservation planning where you can still approach conservation on an ecosystem basis. You don't have to worry about the fine filter of identifying species per species. You can look at ensuring that rare habitats are conserved, and for the most part, you'll be able to address many of the population declines. And indeed, if you look at state laws, you'll find that state laws are less focused on the counterpart to the Federal Endangered Species Act and more focused at the general authorities that provide states with conservation mandates for declining but not imperiled species. States need the Federal Endangered Species Act because it is the gorilla in the closet. It is a great motivator for private landowners and businesses to come together and engage in conservation plans, to agree on some common sense solutions. Jay mentioned as an example the lesser prairie chicken. Steve Yaffe, a professor at University of Michigan, has studied public-private collaborations for ecosystem management and has concluded that voluntary conservation efforts generally require some kind of threat to keep people at the table and to keep people negotiating in good faith. So the states need the Federal Endangered Species Act for that reason. At the same time, of course, the Federal Endangered Species Act, to be successful, needs states, right? The overwhelmingly most common risk factor, the most common source of endangerment for species is habitat modification and destruction. Well, who's in charge of habitat modification? Generally, it's the states. And without state authority for land use planning and control, without the states, without harnessing state permit programs to consider the habitat generated declines of species, it's I think, unrealistic to think that the federal services can get their job done. So it's, in some respects, a kind of nice forced marriage that both sides need each other. And it does make the situation, I think, a natural one for more cooperative federalism. And there's certainly no shortage of creative ideas for how to promote cooperative federalism. I want to share with you a couple of studies that I'm in the midst of right now that I think may be able to contribute some information that will help in cooperative federalism efforts. I'm going to talk about two projects very briefly. One is a project that looks at state endangered species statutes. They're not always called endangered species. They're sometimes called protected species. We might just say imperiled species authorities for states. Because that'll give us a sense of what kind of authorities states have to partner with the federal government, to take on some of the responsibilities that would otherwise fall into the hands of the Fish and Wildlife Service or the National Marine Fisheries Service. And then after briefly talking a little bit about that, I want to talk about how 4D rules have been ways for the federal government to recognize and promote more public-private collaborations. First, State Endangered Species Act authorities. One of the big differences that presents a hurdle for the pollution control style, the Clean Air Act style cooperative federalism that Miles talked about, or the Clean Water Act, where states are delegated authority to issue permits that meet federal as well as state standards. One of the hurdles for states to take on that responsibility is that, for the most part, State Endangered Species Act don't have the same action tools, action forcing tools that the Federal Endangered Species Act provides to the services. Putting aside listing, how do the services go about affecting habitat, preventing takes? Well, for the most part, there are two action mechanisms. One is Section 7, which requires that federal actions authorized, funded, and carried out, right, result in no jeopardy to the continued existence of species. Would we expect that states would do that with respect to state actions? Particularly in your western states, states are quite significant landowners, but the interagency consultation is important not just for public land management, but for any kind of state regulated activity. Only 6 states have statutory authority that comes close to the marriage of procedure and substance of Section 7 of the Endangered Species Act, the procedure of consultation, and then the substantive threshold of the consultation resulting in an outcome that avoids jeopardy. Keep in mind that when I say only 6 states have that authority, I mean only 6 states have that statutory authority. We heard in the last panel about an action that the Colorado Oil and Gas Commission took on to ensure that their actions followed consultation with the State Wildlife Agency. So there is clearly some consultation that's going on, at least in western states, but it's not memorialized in statutes. Pollution control style cooperative federalism generally requires states to make more durable showings of legal authority. So states get permitting authority to fulfill responsibilities under the pollution control statutes, but at the cost of having state laws that are closer to the federal authority. And so one thing that Western states have to consider is, would you be willing to strengthen your state statutes if it meant getting more authority from the Fish and Wildlife Service? The other key federal substantive limitation, of course, are the Section 9 prohibitions. And because the most significant cause of imperilment is habitat modification, the aspect of those prohibitions that has been most significant is the prohibition on harm, which the services have defined to include, in some circumstances, incidental take, which can mean habitat modification. Now, 26 of the 50 states have imperiled species statutes that include the word harm, but I suspect that most of those states do not define the word harm to include incidental take. Only 6 states have incidental take permit programs, and that's I think, a window into how many states either define harm to include incidental take to habitat or enforce incidental take. So that's a pretty low showing, and again, I wonder whether states would be eager to broaden their prohibitions. While under the Clean Water Act, most states have stepped up their statutory authorities to meet the standards for the National Pollutant Discharge Elimination System. It's a very different picture when we look at how many states have taken on permitting for Section 404 dredge or fill permits. There, states have almost uniformly refused the invitation to be the permitter. Why? Because it's exceedingly unpopular for a state to say we're going to regulate this private land activity that involves wetland destruction. We'd rather the federal agencies take the heat for that. And so that makes me not pessimistic about more cooperative federalism with the states, but I think we need to be realistic about how willing states might be to take on greater responsibilities. On the imperilment side, I think for the preventing declines to the point at which they cross the threshold of imperilment, states have the authority and the capacity to do a lot more with the services. Okay, real quick, another research project I'm undertaking has to do with the 4D rules that Jay talked about. These are rules that allow the services to tailor and often moderate the otherwise draconian prohibitions in the statute for species that are threatened as compared to endangered. I'm working with a couple of colleagues reviewing all the 4D rules. 4D rules apply to about 50 to 75 species, depending on how you count them. Many of the rules apply to multiple species, so you have a rule for, say, West Coast salmon evolutionary significant units. Okay, how many species is that? It's one rule, but multiple species. The more important number is throughout these rules, there are 138 special exceptions. So this reflects, in a sense, 138 tailored collaborative deals, right? These are the services recognizing that a state has put together a permit program to deal with a particular problem within its boundaries, or that there is a multi-party plan that if people within the planning area comply with the plan, then they will be mitigating activities or minimizing activities enough to avoid harm and, in fact, maybe even contributing to conservation. Most of these rules pertain to fish. We're talking about 52 fish species, 38 mammals, 11 reptiles. I'd say the biggest headline for my review of all the rules is that a majority of them, more than 100 out of the 138, involve some sort of practice-based permission or restriction. So what I'm saying when I talk about practice-based tools is to distinguish that from threshold-based. The big problem with Section 9 is threshold-based. Is the result of this activity a harm? How do you know? How do we measure that? That's very difficult. In contrast, and particularly borrowing from the pollution control side of cooperative federalism, in pollution control, we usually say, oh, best available technology, right? If you're doing the best you can, then we're going to say you're doing a good enough job, All right, we're not going to measure outcomes. We're going to permit activities based on the way in which the activity is conducted. So whether it's defining the activity as normal agricultural operations or state permitted recreational fishing or incidental to a particular plan endorsed by, say, the California State NCCP program, the most common tool promoting collaborative conservation is this tool that says the service has looked at a particular practice and made the finding that there will be no concern about take liability if the action is operated along the lines of the practice as defined in a plan or as authorized in a permit. State permits are pretty rare. I've only found about 5 4D rules that say that an activity conducted pursuant to a state permit is an activity for which the permittee does not have to worry about liability. But these are still preliminary results, and I won't get around to checking them until this summer, likely. All of which is to say that there are some challenges. There's some hurdles that have to be overcome in order to strengthen cooperation under the Federal Endangered Species Act. But given the need that both the federal agencies and you states have to work together, my assessment is there's still quite a bit of common ground and opportunity for more working together. A final observation. When I first started thinking about these issues and writing those articles that Miles talked about, I did think of them very much as part of a cooperative federalism framework, and it was much more informed by the pollution control experience. Now, though, I think about these issues more along the lines of public-private conservation. I think the most important development of the past 15 years in the Endangered Species Act has been the rise of private landowners and corporations stepping up to the table and participating with states, and in some respects more strongly than the state agencies, to negotiate site-specific and threat-specific deals in order to promote the conservation of species. So really, I think it's fair to look at cooperative federalism as a vehicle through which not just state authority is brought along for conservation of imperiled species, but also a kind of bigger ship that includes a lot more stakeholders than was the case, say, 15 years ago. Thanks very much.
Okay. So I'll try this. Let's see if this works. Okay. Let me start out by thanking everybody for hanging around. I guess I've got the honor or the misfortune of being the last speaker, but I appreciate you. I appreciate Zach, the invitation, and the WGA for allowing me to speak. This is as people have mentioned, this is a panel. This panel deals with a very broad topic, and I was struggling a bit with what to talk about. And I thought using critical habitat, which Noreen has set up a little bit for me, might be a way to sort of go over how the ESA has evolved, how it's changed over time. We talk a lot about amending the ESA, reforming the ESA, but critical habitat is a good example of how Congress, when it passes a law, we don't always end up with that law being implemented the way Congress intended. And critical habitat, and the ESA generally, but critical habitat in particular, I think is a good example of that. So let me start off with actually I'm going to go back to 1973 first.
1973, the ESA is originally enacted. It's much shorter than the current version of the Act, which has been amended a number of times, not recently, but it has been amended. Critical habitat appears in one sentence in the 1973 version of the Act. It's the original version of Section 7, which has the requirement that federal actions may not destroy or adversely modify critical habitat. There's no definition, there's no process or no procedures for how critical habitat is designated. So we have one sentence. Federal agencies don't know what to do because, again, there's no guidance. This is a completely new concept. And in fact, frankly, a lot of federal agencies were simply ignoring the Endangered Species Act after it was enacted in 1973. And the Fish and Wildlife Service and National Marine Fisheries Service, therefore, were put in the position of having to interact, in some cases, from what I've read, in a fairly hostile way with their sister agencies to try to get them to pay attention to this new statute. And again, to make a long story short, after 1973, there are policies issued by the Fish and Wildlife Service and National Marine Fisheries Service first, and ultimately rules were adopted in early 1978. And as the slide indicates, this is the bulk of an excerpt from the rule that defined critical habitat for the first time. And as you can see, we see the term survival and recovery being used, which you're probably familiar with because that comes back around in the 1986 definition. But more important, the second bullet, that critical habitat may represent any portion of the present habitat of a listed species and may include additional areas for reasonable population expansion. Now, at the same time, this rule was being promulgated, of course, we had the Supreme Court deciding Tennessee Valley Authority versus Hill and stopping or affirming a preliminary injunction, stopping the completion of the Tellico Dam because at that time it was believed that it would lead to the extirpation and destruction of the critical habitat for the snail darter. And there were other lawsuits that were pending challenging major federal projects. As a consequence of this, Congress was very concerned in 1978 about the Endangered Species Act, how it was being applied. Again, given the fact that I have a very brief time today, I can't go into detail, but there are some very strong statements by both senators and representatives that the ESA was not being applied the way Congress intended when it passed in 1973. And one of the areas that was very highly criticized was critical habitat. And what I've got in the slideshow, there are other examples, but this is an excerpt from a Senate report. And again, as you can see, this is, and you can read that for yourself, but as you can see in the view of Congress, critical habitat was intended to be that habitat that's truly critical to the continued existence of the species. It's not supposed to be habitat that is protected in order to extend the range of the species. And the example given in the Senate report was the proposed critical habitat for the grizzly bear, which again, according to the Senate report, was not habitat necessary for the continued survival of the species, but instead was intended to allow the population to expand into other areas. So again, because of limited time, I could give you more examples, but the ESA was pretty substantially amended in 1978. And in terms of critical habitat, the definition of critical habitat was added. It's a two-part definition. It distinguishes between occupied and unoccupied areas. In addition, the bulk of the process that we follow today when critical habitat's designated was adopted. And there's also the requirement that the consideration of economic activities also occur in connection with the designation. And this slide basically summarizes the themes. That the real purpose of critical habitat is to ensure the species' continued existence, its survival. And again, that's very clear in the legislative history. It should focus on areas that are currently occupied. It shouldn't be designated for future population expansion. And again, there was this blow-off valve, Section 4B2, that allowed areas to be excluded. Pardon me. And here's an example of an early interpretation in the courts, Northern Spotted Owl versus Lujan, which was decided in 1991. And this was a case where environmental groups sued the Fish and Wildlife Service for failing to designate critical habitat for the northern spotted owl. And one of the primary arguments made by the government was that the Fish and Wildlife Service, along with the Forest Service and BLM, were currently working on a comprehensive conservation plan for the Pacific Northwest to protect habitat for the owl, and therefore it should be excused from designating critical habitat until that plan was completed, and that plan could then inform the critical habitat designation. The court rejected that argument, again, based on the legislative history, and the court has a fairly detailed discussion of the legislative history from 1978 that I just summarized. And again, the slide provides the court's summary description of what critical habitat is. It's the minimum amount of habitat needed to avoid short-term jeopardy or habitat in need of immediate intervention, consistent with the legislative history. And as I noted there, the Northern Spotted Owl case was cited and quoted by the New Mexico District Court in the Middle Rio Grande Conservation District case, which was affirmed on other grounds on appeal by the 10th Circuit. So there's still some validity for the discussion here in Northern Spotted Owl. Well, again, time limitations. Fast forwarding, what have we seen over the last 10 or 15 years? As Noreen said, there are new rules out, but those rules don't change anything. They simply codify what the Fish and Wildlife Service has been doing since 10, 12 years ago, say. And the trends have been treating habitat as recovery habitat for future population expansion. Larger and larger areas are being designated for critical habitat, including areas that actually currently lack suitable habitat. And the example I like to give is the southwestern willow flycatcher. Some of you have probably dealt with that species. I mean, in 1997, there were 599 to be precise, river miles designated for the flycatcher in 3 states, Arizona, California, and New Mexico. Critical habitat was redesignated 2 subsequent times because of lawsuits that set aside the prior designation. The current designation, over 1,200 river miles and over 200,000 acres of habitat were designated as critical habitat for the flycatcher. So when you look at species, I could give other examples where we saw critical habitat designation, say back in the 1990s. And again, as panelists have mentioned, the reason most species are listed is because of effects to habitat, either past or anticipated effects. We see that sort of pattern. The other thing we see is that areas are being declared occupied without credible evidence of regular use. We saw a bird was detected 5 years ago, therefore it's occupied. I've got a situation with a client that's almost exactly that. And again, land is almost never excluded. I put almost. I can't think of a recent occasion where land was excluded on economic grounds under Section 4B2, but I qualified it because I can't say that it's never happened. What's happened is 2 court decisions, and this sort of, again, was the basic topic of this panel. 2 court decisions, Sierra Club versus Fish and Wildlife Service, decided by the 5th Circuit in 2001. The Gifford-Pinchot Task Force, decided by the 9th Circuit in 2004. That effectively rewrote the law. The Sierra Club case, and again, I'm almost out of time. I think I've got, please wrap up, 1 minute, okay. I'm almost out of time here, but the Sierra Club case involved a challenge to a decision not to designate critical habitat for the Gulf sturgeon. The 10th Circuit in that case totally blew, I don't know how else to say it, the legislative history. They looked at the 1978 legislative history, acknowledged that Congress had rejected the 1978 rule defining critical habitat, and said Congress rejected it because it wasn't narrow enough. When, of course, as I explained, exactly the opposite happened. Then the Ninth Circuit, 3 years later, relied on the Sierra Club case to find that the purpose of critical habitat is to recover species. Again, Congress said that destruction or adverse modification could occur when sufficient habitat is lost so as to threaten a species recovery, even if there remains sufficient critical habitat for the species survival. Again, exactly the opposite of what the legislative history indicates. So to wrap up, we now have new rules defining destruction or adverse modification of critical habitat. We also have extensive changes to the regulations that deal with critical habitat. Adverse modification is now based on Gifford-Pinchot and Sierra Club. Impacts to habitat that may impede recovery can result in adverse modification. Again, 180 degrees from what Congress intended. And again, I'll skip over this. If we look at some of the changes to the regulations themselves, we see conservation, conserve, and conserving, which is a definition in the statute itself being revised to include, i.e. the species is recovered, to emphasize the link between critical habitat and recovery, even though, again, Congress had said critical habitat should not be used for future population expansion. And we have additional changes that, again, indicate that critical habitat may include areas that aren't occupied and don't contain habitat capable of supporting the species. Again, critical habitat being designated for future population expansion. So as we can see, to wrap up, there's been essentially, I guess I could have called this presentation Back to the Future. What we've seen is Congress reacting to what it believed was an overbroad definition of critical habitat, and then as a result of litigation in the courts, critical habitat is redefined, and then, again, to be candid, as a result of politics, the agency says, okay, what's fine, we'll go along with these court decisions, we'll redefine critical habitat and turn it back into habitat for population expansion. Thank you.
Nothing like the last panel that gets provocative, disagrees with itself from time to time, and offers us much fodder to talk about, all with about 8 minutes left for questions. I don't know how long some of you are here after the conference ends here in a few minutes, but if you are around longer, I'm sure people would, and you'd be willing to chat with people, because boy, there was a lot there. I don't know who to call on to ask a question that could go for the next 3 hours, but we'll try to make that good question last about 10 minutes. So we've got now you've asked before, and I don't want to ignore anybody, but at the same time, if there's somebody that's not asked a question that really wants to ask a question this time. Got a guy over here, because I always want to include as many people as possible. We probably can get at least a couple questions, so.
I'm a subservient landowner, and here I stand amongst you as a dog face as far as I'm concerned, and you are the generals. You all go into battle, and I appreciate that. But you are like General Patton. Your guts and our blood in the field. My question to you, anywhere through this legal process, do you ever think of the poor guy that is trying to produce food for all of us and for the species? On my property, there are 72 species that I can count, from the lowly dung beetle, which I have to admit, I did clean off his habitat before I walked into this room. But the question still goes back. Do any of you ever consider the landowner and the one who is actually doing the work?
May I take a shot at that?
You sure may.
And I think maybe this is more a question for Jay than for me, but I mean, that's who I represent, frankly. And the problem bigger problem I see with respect to the Endangered Species Act is whether it's a landowner, whether it's a business, a mine, a rancher, whatever, you're in business. You don't want to be litigating in federal district court, which is your point. You just want to be left alone. You want to be able to use your property in a reasonable manner, subject to reasonable regulation. I certainly get that. And as a result, one of the reasons we see decisions like the two I just discussed, Gifford Pinchot in particular, is on the other hand, we have NGOs, we have special interest groups that for every lawsuit that gets filed by landowners and business groups and associations, pick a number, 20, 25, 30 times as many, a constant barrage of suits. And eventually, you're going to win. You're going to hit the lottery, and you're going to get the Ninth Circuit saying that the purpose of critical habitat is for recovering species. So, to answer your question, yes, I certainly care about landowners because that's who I represent. It's unfortunate that we can't respond in kind and push back. But again, litigation costs money, and you don't want to be in court. You want to be farming, you want to be mining, you want to be ranching, whatever it is. And so there's this imbalance that is also, I think, been a key driver on how the act has been interpreted and applied over the last 25 or 30 years.
Yes.
I guess I should take a shot at it too from the other side. I think you're fooled by my suit today. I worked on a ranch throughout my teenage years. It was about 50 miles from Laramie. I spend my weekends now working on a ranch that's 13 miles from Lamar. So I do think about the people who are on the landscape ranching. I also think about the people like the Marielle and Morrissey, the story I told, who waited 19 years, a time period during which she died, for the government to tell her if she was right or wrong. So I see both sides of that equation.
Okay, over here. Get your hand up.
I'll direct this to Miles, but certainly welcome any other input. I'm going to go along with your metaphor of surgery, and you're recommending an elective surgery on a vital organ. And one of the first things I've ever done when I've had to look at surgery is check on the survival rate of the patient. I'd like to hear you explain to me how in the current atmosphere and with the surgeons that we would be turning ourselves over to, we would have a survival at the end of the process.
Well, one of the underlying themes that I've picked up on over the last couple of days is this need for cooperation between all the parties. And understand, this is not an easy goal. And I'm not sure even the term elective surgery or phrase elective surgery is what we're talking about. In some cases, it might be surgery that's forced upon the patient. But I want to reach out, and that's why in my remarks I said I'm not suggesting a weaker Fish and Wildlife or somehow a diminished Fish and Wildlife Service. What Jay talked about, which was that the states were the entities managing the species, and somehow the species were not recovering. So we used his organization and the people he represents used the tool available to try and take that authority away from the states and put it on the federal government. So my suggestion is consistent with his, which is that because I see states that need to be further empowered to work with these species and save these species. And I think if we can cooperate and we can bring both sides of the table together, because I'm not adverse to Jay on this issue. I think a stronger state focus on these species will help these species and should be something that is acceptable to all parties. But I recognize that certainly with this election cycle, that's a difficult lift. I'm not suggesting it's not.
Other questions from anyone? I think you're all kind of, I don't want to say stunned, but a lot of stuff to think about here. Okay, it's late. in terms of the conference. I think this last panel gave us a lot to think about. So join me in thanking them for coming from various places to talk to us. I'm going to turn it over here in